Employment drug testing is on the rise, especially with the opioid epidemic that's making the headlines every day, with fentanyl in the news, as well as with marijuana becoming legalized in some states, even though it's illegal in others and illegal federally. So we're going to talk about the top 5 mistakes employers make when drug testing. Quite often employers call in to set up drug testing when an emergency situation happens that they're not prepared for. And usually not having a policy and not having prepared for the situation leads to severe problems and possible legal liability. One of those that I hear quite often is about using instant testing. There's nothing wrong in and of itself with using instant testing. It's a valid test. However, if it's a non-negative result or comes out with an initial positive result, you can't take action on that as an employer without encompassing some liability. So that test actually should be sent to the laboratory, confirmed, and then sent to a medical review officer who would then contact the employee or the person being tested to verify if there's any prescriptions involved. Now, one of the situations we have quite often is when employers actually take an adverse action on an initial screening test. And that means they're actually conducting the test themselves, they get a positive result, and they say that's it, and they take an adverse action, meaning they terminate someone or discipline them. That's going to open them up to legal liability. We've also had instances when they're not using someone who's very knowledgeable in drug testing for their collections. Very recently, we had someone send a driver for them to a hospital-type facility. They did an instant test, and the hospital facility actually released that instant test result without confirming it. They immediately terminated the person, even though it potentially could have been a valid prescription. And now there's a lot of liability involved with that. A second thing that comes up quite often also involves instant testing or getting a result that's not been reviewed by a medical review officer. And that's when an employer actually gets a positive result that hasn't gone to a medical review officer who has to be a licensed medical doctor, who has a certification to review medical results from drug tests. And so that employer then takes it upon themselves to contact the person and discuss their medical history. They ask them to bring in prescriptions and medical records. The violations there, if there's any attorneys listening to this, they're just cringing at this point, especially if it's your attorney, because this happens quite often. I just had a call yesterday about that, where they had taken adverse action on several people based on information that they had gleaned from that interview process. And that, again, is protected medical history. So that's a very big mistake. If you're doing that, not reviewing your results with a medical review officer before taking action, you could be opening yourself up to a serious liability. A third situation that arises is when we make assumptions about drug testing results. Drug testing results typically take a specific period of time. If it's a negative result, you might have the result in 24 to 48 hours. However, there's several things that could delay that process that have nothing to do with it being a positive test. And making that assumption that just because you did not get a result within that 24 to 48 hours or whatever your standard time frame is a very big concern. There are things that could slow it down, such as delivery time. So maybe the collection of that drug test was done on a Friday afternoon. That means it doesn't get shipped to the lab till Monday. That means it doesn't get to the lab till Tuesday morning. It doesn't go into testing till Tuesday. And then if there's a confirmation needed just to make sure or anything like that, that could be an extra couple of days. Or maybe there's a holiday on the Monday and it was collected on a Friday. It could be that the collector did not complete the form correctly, and that delayed the process because they had to have a memorandum of record because something wasn't checked off. So there's any number of things that could have delayed it. One of the things that delays it quite often is once the test is completed, which is done very quickly, the lab confirmation, if needed, is done very quickly. It gets to the medical review officer, and then the medical review officer is required to contact the employee or the person being tested. And they have to do that because there was a positive test result, and they have to verify a prescription. And the employee doesn't get back to them. And they leave message after message, and they can't get in touch with that person. Obviously, they can't release the results for a period of time. So that could delay it, even though it could be a valid prescription. So if an employer makes an assumption or a supervisor makes an assumption about that and starts talking about those kind of situations, it leads to rumor, gossip. And then there have been many lawsuits specifically because of that rumor and gossip about a specific test result when there was no actual evidence of a positive test and no other evidence to go on at all. This is one of my favorites. So the fourth in our top 5 today is the random reasonable suspicion test. And if you heard me say that and you went, that doesn't exist, you're absolutely correct. It does not exist. But a lot of employers, they don't want to send somebody for a reasonable suspicion test, or they don't have a proper documentation. They don't actually have proof or evidence, but they just think that the person is doing drugs or somebody told them that they were. So they call up and say, hey, we want to send them for a random test. Well, that's actually not a random test. And again, that's a legal liability issue as well, because even if they do test positive, so they're going to talk to an attorney. The attorney's going to come back and say, show me how they were randomly selected. And you're not going to be able to do that. You're going to say, well, it was reasonable suspicion. Then they're going to say, show me your documentation of reasonable suspicion. And you're not going to have that. So that's another situation that comes up. And that's why it's very important to work with a good drug testing provider that can help you when these issues come up, make sure to guide you in the right direction. And the last mistake that the employers make, that's one of our top 5, is not having a drug testing policy in place. A lot of the issues that come up from time to time are addressed in your policy. How to handle something if somebody tests positive for drugs. What if they test positive for alcohol? Do you have a second chance agreement? Do you have to refer them to a substance abuse professional? Do you have an employee assistance program? All of those things should be covered in your policy. What drugs you're testing for, what test panels are available that you can use. So those are all things covered in that policy. A policy goes a long way to help mitigate a lot of the other issues that do come up from time to time. Now, there's many other mistakes that could open you up to liability as well. So if any of these hit a chord or a note with you that you said, well, maybe we need to look at how we're doing things, reach out to National Drug Screening, run things by us. Whether you're a client or not a client, we're happy to talk to you and help steer you in the right direction. There's also a lot of great information on our blog, the NDS blog, at www.nationaldrugscreening.com. You can search for any of these errors and many more, and we'll give you solutions, things you should do, as well as best practices. Thanks for joining us, and we'll see you on the next video.